Okay, what is the difference between obstruction of justice and perjury? And reading the trial lawyers from about 1987, there was one case towards the back with Edward Bennett, 1988, with Edward Bennett Williams as the lawyer for John Connally, who was a governor for Texas and was actually in the motorcade when John F. Kennedy got shot. John Connally was sitting right in front of John F. Kennedy and he got hit in the back. So he experienced that, and he was well known for that, for surviving that. And then later on he got sued in the 70s for two $5,000 payments from the milk industry to give them favoritism, to help them raise prices for milk so they could make more money. And the government seemed to have gone out of their way to prosecute him. And that's what this trial came about. And it's interesting how they talk about perjury, in that it could just be used against you quite easily, very similar to obstruction of justice. Perjury is when you go in front of a group and you swear to tell the truth and nothing but the truth, and then you lie, or they accuse you of lying. Close enough. There's a gray area between a definitive lie, which the government believed they could prove. That's why they made the charge. And there were two counts. He actually got an obstruction of justice charge too. That wasn't really talked about, but this author went into more detail of the perjuries. One obstruction, two perjuries, and then the charge, which was the ultimate criminal charge, was taking a gratuity for the milk industry. And actually, I liked how they talked about the difference between a gratuity and a bribe. A gratuity is in advance of something favorable coming your way. Yeah, a gratuity and bribe are different. Okay, under the law, let's see, I'm just reading it now. He got charged with accepting gratuity. Yeah, under the law, they differentiate the gratuity and the bribe. The bribe is paid afterward. The gratuity is paid beforehand, pretty much. So he got charged with the gratuity, and it came down to a he said, she said type of thing. Although it was more of a he said, between John Connally, who is he was like I said, the governor of Texas, but then this was at the time he was the U.S. Treasury Secretary, and another guy, last name Jacobson, who claimed that he gave Connally the money, or put it in a safe. There's like back and forth. That's the he said, she said stuff, because it's one person's word against the other, and it came down to credibility. Who has more credibility? And they felt that Jacobson, which is interesting, he had, this is something that takes a lot of investigation, a lot of money, I'm guessing. They had to research beforehand what Jacobson testified to about the money, under whatever circumstances he made a testimony, and then after the government like offered him like not asylum, it was immunity. Then it came in that he changed his testimony and said that John Connally took the money. He testified before that it was just kind of held in a safe, and then after the government offered immunity, he said that Connally actually took it. So it's interesting how the government, this was a very complicated case that can be looked up just looking under John Connally's Wikipedia. But it's interesting the difference and similarities between obstruction of justice and perjury. To me having gotten an obstruction of justice charge, in this case, they talk about separating the crime, the trials for the crime of perjury. Okay, so and then the actual perjury and the obstruction of justice, two separate trials to simplify arguments for the defense. And they made sure that the gratuity charge, the biggest charge, was held first. And you know, if you win that, then the perjury and the obstruction of justice fall. And that just makes me think, for my situation, when I got that arrest in Horseshoe Bend, Idaho, for obstruction of justice, there was nothing for it to be propped up on. If I wanted to make an argument, okay, let's make two separate trials. Let's separate the criminal trial from the obstruction of justice. Well, there was nothing to hold this obstruction to. And it's curious how that works. When obstruction of justice charge is filed, how often is the Justice Department able to follow through on that? And that comes down to getting public records requests. But I mean, how do you research that? You can't expect the court reporter or the records keeper, the secretary, to compile everything for you perfectly in a nice statistical manner. You know, make a little graph for you or something. They don't do that. So it takes some expertise to find that out. It is just a curiosity. How effective are they? How are the law enforcement at making obstruction of justice charge actually stand on its own? I'm sure there's cases where they've won it, but I'm thinking they probably lose most of them because there's just nothing to stand it on. But if I actually got charged, say I got charged with trespassing and then obstruction of justice, it might be in my best benefit to just separate, to simplify, because if I have to go through court arguing these two separate charges, it really makes for a complication that can be kind of avoided, because obstruction and perjury are really just add-ons. As this guy said, he actually, this lawyer, Edward Bennett Williams, had to argue to the judge to separate. Not all judges would actually separate them. It depends case by case. But this lawyer, he's kind of made it his profession at the time in the 70s and the 80s to do that, because that's a lawyer's main focus is to simplify the argument. If like with O.J. Simpson, if the glove don't fit, you must acquit. He actually made it a nice rhyme. You want to make it simple for the jury to understand, and just stick with that one idea and just keep pounding it. But you got to be good at that and keeping the focus. It's not that easy. Just to keep referring back to it. You have to know how to refer back to the simple idea. And I can't believe that with my case, it was about delaying my situation. They could have dropped it at any time in between this. Boise County, Idaho could have dropped my case anytime within that 60 days. They could have dropped it. They waited the full 60 days, and they kept making arguments. Even in court, they were like, "Oh, we're gonna try to work this law and that law." They were making all these excuses, especially to try to delay my case to support this cop's singular charge of obstruction. And it's really frustrating to see. My public attorney really didn't seem to have any problems with that. You know, he gets paid by the hour. For me, I'd like to try to, you know, hurry it, get an expedited processing of something so silly. But I mean, you have to take it serious too, because there's people involved. The cop makes the charge, and suddenly you get the judge involved, the secretaries, lawyers, and those other clerks, the clerk of courts. They're all, you know, suddenly this cop's employed all these people. And it makes it very serious. I mean, if you ignore it, of course, it gets even more serious. So you have to take it seriously. But there's better ways to approach these types of things, and it's interesting. An obstruction of justice charge, just the way it's described in this book, you want to separate it from the crime. But if there's no crime, then there's nothing to separate it from. It'd just be silly to, you know, whatever charge it is. 2 days? Is that what McIntosh wanted? 2 days? Then I would ask that charge be addressed by itself, and we could talk about that in the courts, and then after that, you know, this obstruction of justice, if the 2 days law can't stand on its own, then the obstruction of justice certainly can't either, because there's no law. How about when that one cop pulled the gun on me? There was no charge, although he said, you know, it's a failure to ID, but for what? What does it stand on? It's something. The failure ID would be a secondary that I would ask to have maybe another court date for, depending on whatever charge they wanted to make. Oh, there's children present. I stayed overnight in the park. You know, the hearsay. Talk about that first. Let's talk about that, and then talk about your failure to ID charge after that. Separate. You want to separate. It's like how they like to separate people. You want to separate the issues and talk about singular issues and simplify it. Don't just make arguments for everything. That's a lot of lawyers. There's 10 lawyers that were interviewed, and a lot of them want to simplify and separate the charges. Although there's a lady in here, they got diversity. She wanted to address everything, so maybe that works for her. But most of the males wanted to simplify, keep things separate. And I think that the actual criminal charge being separate from these add-ons, and he made the argument for that. I'll read it. I argued substantially that if the government could indict you for perjury, for denying the thing that they were accusing you of, so you deny it, and then you get perjury for denying it. This guy denied that he accepted $5,000 from the milk industry, and so count one, denied that first $5,000. Did you take the other $5,000? No. Perjury charge, count two perjury. Just incredible. and then they wanted to tack that on to the gratuity, like the charge for gratuity, however they worded that. So in every case, they could call the accused before the grand jury or the Senate or maybe a city council, wherever you swear to tell the truth. And when he denied that he committed the offense, they just add perjury counts. They say he lied, and that they added perjury accounts, one for every denial. They could add a perjury account, one for every denial. And that's the thing, for obstruction of justice, how many times can you obstruct justice? I think only once. You can only get one charge of that, and then after that, what happens? You know, they get you in the court so that you can start adding perjury charges to the charge. You know, that's what it's a wicked system. The way some people can play that game, but you just have to know how to respond to that so that you can come out ahead. This would be a totally unfair thing to do. It would be a way of multiplying offenses. And then he said Judge George L. Hart Jr. apparently agreed with Williams' logic because he granted the motion. But not all judges are going to agree with the logic. And it'd be curious to know, when they agree, do they explain why they agree? When they disagree, you definitely want them to explain why they disagree. But when they agree, it's just like, we don't need an explanation. What you said, your argument stands, he's just agreeing. But disagreements, that's something to learn. That's something you want to know. So, Connally won under Edward Bennett Williams with because it's a big trial, and it's not explained on Wikipedia. It's not even mentioned. Well, it's mentioned, but it's not mentioned in such great detail as in this book. The first trial was won, and then the second trial was like dismissed. So separating that was really easy for this situation, and I think it could really work for a lot of situations. You just have to know how to work with the system. There's no exact law about separating charges and making them different trials. Some people may not want to do that because it can cost too much money. Connally's was a rich man when he was alive, most likely. How much time and money do you have to spend on this type of thing?